of the pretrial processes work group. I'm retired Judge Deborah Garrett, and we have a quorum for the meeting, so we're beginning. Afternoon, everybody. Hope you're all doing well.
Good afternoon.
All right. Hi, Judge Jones. Nice to see you.
You too.
Yeah, nice to see everybody else as well. And so our meeting agenda is not huge today, but we do have some information from Judge Jones and Alan Epps, who've been working together on what looks to me to be a very promising looking bench card that can be used by everybody. I'm going to turn it over to you, Judge Jones and Mr. Epps, and ask you to explain to us what this is all about.
All right, thank you, Judge Garrett, and good afternoon, everyone. So Alan, as the manager of pretrial services, and myself have been spending quite a bit of time together, I think, but making efforts anyway to do what we think is important to educate the commissioners who make decisions at first appearances. One, about what the rules are that govern the bail decision, conditions of release decisions that they're making every day, and two, what options they might have through our pretrial services department that the court offers, and both to encourage them to utilize those options in cases that make sense, but also just to educate them about what's happening. And so those we thought that was important to do. I think that that urging probably came out of this group in particular, but also just generally we recognize it's important. So we've worked on the bench card. We circulated what we have so far. It's a draft card. We are definitely encouraging, receptive to comments about what could be on there, what might be helpful to the commissioners, what decisions they regularly face, those sorts of suggestions. We did have we did meet with the commissioner. When was that, Alan? 2 weeks ago. 2 weeks ago or so, we met with the commissioners and invited all the pro tem judges that serve on our first appearance calendar in Superior Court. We had some participation from those folks, and we introduced the bench card to them and solicited in the same way I'm doing here, but we solicited any feedback they might have. So I think we're making progress, but we're just kind of open to a discussion about what more we should be doing. But Alan, is there anything you'd like to add there? Or?
No, I guess the only thing I would add is to I guess ask is to make sure everybody got the card. And if there is any questions about, I would imagine most of the questions might be circulating about that large grid on the back that says release conditions and actions. Because I know it's been brought up by the defense and the prosecution at times, what's the process we take if somebody is in compliance or is not in compliance. So that's probably where I spent more of the time, and I compared what I did here with Thurston and Pierce and some of the other counties that I'm in contact with about basically this grid exactly of what it should look like and what our responses should be if something if they were to get a new criminal offense, or if they were to not report to pretrial services and things like that. So a lot of this was based off of what's already been in practice around our state, or at least the agencies I've been in contact with.
Alan, Judge Jones, I'm prepared to screen share the bench card if you'd like me to. Just let me know.
Yeah, I think that'd be reasonable. Yeah.
So the front side of this card is just what we understand as the general law that governs the release condition decision. So it's a pretty, there are quite a few laws that govern it, quite a few court rules, case law, things like that. So we summarized pretty significantly what we thought might be important there. We want the commissioners to be utilizing Criminal Rule 3.2 and be doing it in a way where they're actually referencing the rule to justify decisions they're making. So there's, under that court rule, there's specific factors they are to consider. findings that they need to make in order to justify certain conditions of release. So we want this, and we encourage the commissioners to be more to make sure that they're making a case-by-case determination based on actual concerns being presented to them, factors being presented to them that then lead to certain conditions being imposed. So the recitation of all those factors, the rule being put there is meant to just encourage that real case-by-case specific review of conditions being set. And then, like Alan said, the back side of the card, which is all pretrial services stuff, is, I think the commissioners here in court sometimes that pretrial services is not effective, or it's not going to be effective to manage risk that that individuals might pose. And so we kind of made some efforts here to really put out what pretrial services really does and can do. Kind of the reporting of violations, how quickly that can occur, and what happens following a report of violations. Just to try to give the commissioner some confidence in how they might manage risk by adding pretrial services to a particular case. So that's kind of the overview. And Ms. Vanyo, did you have a question?
Oh, thanks.
Yeah.
Yeah, I was excited to see this, and I wanted to bring compliments to be passed along to Commissioner Keeler. I think yesterday, she was very thoughtful and on the record made very clear findings following the rule. And our staff noted it and has been commenting on it, and we're really appreciative of that. I know that she likely attended the judicial conference recently, so that may have been, maybe she saw a great lecture there that re-inspired her to closely examine the rule and walk through the findings that need to be made. But I thought also maybe this bench card had something to do with it. So thank you for your efforts on this front. I noticed that on conditions of release section on the page 1, you cite the RCW that talks about no work release, electronic monitoring, day monitoring, if violent or sex offense, and violent or sex offense in the last 10 years. I just want to clarify and we do have a pretrial supervision program, but these other cited conditions are not ones available to us in this county. I didn't know if it was just the intention to just sort of recite what was in the statute, or if there are efforts to bring these other kinds of monitorings to our county.
That's a really good question. And we had some feedback similar to that from the commissioners themselves. They say, hey, you mentioned EHM all over this document. We don't have that available. We are having conversations about EHM as a potential condition of pretrial release. I don't mean to imply that conversation's very far along or there's plans in place or anything like that, but we are actively having those conversations. And I met with the civil side, the civil lawyers, a couple last month or so, to ask questions about things that I've commonly heard about liability to the county, stuff associated with the EHM program. So I'm asking the questions and trying to encourage the conversation to add EHM as an option, electronic home monitoring. I think what we have available is a contract process through a place like Friendship Diversion Services, with a contract from the county. Would be utilizing pretrial services as a part of that process. These are just conversations we're having.
Thank you. Yeah, I think I guess, like, from a defense perspective, it can get, we all, of course, always want to work with the presumption of personal recognizance, and we want to make sure that these conditions are only imposed when the findings are properly made, that there needs to be a condition, and these are certainly it's less restrictive to have EHM than incarceration. So we would embrace that, but always, again, really appreciating going through those findings and really thoughtfully moving beyond personal recognizance only in the cases where necessary. Thanks.
I have a question about process. First of all, Judge Jones and Mr. Epp, good job you've not only have you taken an initiative and done this, you've done it well. And I really like how the card, which is, you know, just 2 pages, contains so much information, including specifically the 9 PSA factors that are reflected on that other form, and the various release conditions and actions. I think that serves to remind a commissioner on the bench where you're trying to think fast about the various options there are. It's nice to see them listed so that people can refer to them quickly, because it's in a pretty quick context that these decisions get made. My question is about process, and when this bench card is finalized, obviously the commissioners making the pretrial release decisions will have a copy on the bench. Will they also have a copy of the PSA evaluation with factors as completed by pretrial services? Will that also be on the bench as we've done in the past?
Yes, yeah, we still, Kelsey and I, still continue to do those daily on everybody that's gonna be on for first appearances. And just like the bench card says, there's only a few exceptions of who we wouldn't complete it on. And that would be a fugitive matter, somebody who's already in custody, and anybody on like DOC.
Yeah, and I see you've got that listed there as well.
Yeah.
Yeah,
And we actually identified some gaps in that, didn't we, Alan? Because some of the pro tem commissioners that don't regularly hear the calendar, they weren't quite sure how to get access to the PSA all the time. And didn't we work on that,
Yeah.
Alan?
Yeah, we did. I was sending it to the list I had, but I was neglecting to add the pro tems to it, because a lot of times they either wouldn't get the PSA, or it would be given to them last minute and they would say, what is this? So the meeting was, I would say it was long overdue, and I was glad we had it, because it brought everybody back in the loop. But yeah, they're added to both Kelsey's and my emails now. When we send out the PSAs in the morning, they get them now.
good. All right. It's been a while, obviously, but when I was in the initial stages of this committee, I went to the county council to get funding for what has now become our pretrial services unit. And at the time, the judges were not enthusiastic about incorporating electronic home monitoring as one of the services, not because of a judgment about the effectiveness or the benefits of that, but because it was simply too much to manage at that time. And also at the time, there were some questions about the resources for providing that and the reliability of the reports that we were getting. I think those issues have since been cleared up. But when we went to the county council, frankly, the council was more than willing to consider electronic home monitoring. And they awarded a fair amount of money, as I recall, to district court. Bruce, you may be better remembering this than I, but district court was already using electronic home monitoring, and the council wanted to see more of it on the district court side. We did our initial pretrial services unit establishment with the understanding that we would continue on to try to expand the options available to commissioners making the pretrial decisions, and then to the pretrial services department itself, and that those options would one day include pretrial monitoring. And at the time, now this was a while ago, this was what, pre-COVID, the council was very receptive to the idea of electronic home monitoring, including receptive to the idea of funding that directly to the Superior Court, or for some sort of joint arrangement between Superior and district courts. I don't know if that's still the case. Obviously, COVID changed a lot of things, and the politics are ebb and flow, and I don't know. But just to remind you and tell those of you who weren't there at the time, the council was quite open to the idea of funding electronic home monitoring. So we might want to think about how that should fit into the scheme of various services and options. Yeah.
Yeah, I appreciate that. And I don't know how recent, but we have some good, when I started thinking about this about 2 months ago or so, there's some really good examples of contracts and things that the city of Bellingham does with Friendship Diversion Services, some ways that they manage their liability and the way they fund the program. So there's some models even in our own community now that we can look to. We obviously have to recognize in Superior Court we have a different population sometimes of defendants and those accused of things that are different sometimes in district court, municipal court. So it's definitely not for everyone in Superior Court, but it could be for someone. Yeah.
Exactly. And of course, I know the Superior Court jail population I guess the jail population has changed quite a bit since the COVID emergencies. So it's not for everybody, but it's a potential resource. Yeah. Frankly, there was no room to talk about that over the last couple of years because we've been too busy addressing other priorities and moving things along and recovering from the COVID crisis. But it looks like we're getting there. And so this might be the time to at least think about approaching the council. Yeah.
I know Carol's had her hand up for a while.
Thank you. I didn't see Carol. Carol, you want to? I don't even see
Oh,
you on
sure.
the screen. There you are. Okay. Hi.
Thank you. Thanks. Yeah, I just had a quick question about the referrals to pretrial services. It's great and very helpful to see the grid of the different service levels provided at the different risk levels. And I was curious, does that mean that everyone is referred to pretrial services and gets those services at the different level, or is that a release condition decision to refer certain people to pretrial services? And if so, then I was wondering if there's any guidance about who's getting that referral and who wouldn't.
I can touch on that first, and then if Judge Jones wants to take over, if I miss anything, he can add to it. So it's still at the discretion of the bench. The PSA is given a low, medium, high score. They don't have to just say you're high because that's what it says. So no, it's not 100% referral rate. It's still a case-by-case basis based on, I can't
Excuse me
guess.
just a minute. I don't mean to interrupt. I'll be back. I'm getting an important phone call. Thanks.
Okay. So I lost my train of thought. I'm sorry, but the commissioners still have to make that decision on the bench of who is right fit for pretrial services. Is there anything else you wanted to add to that, Judge Jones or Mr. Graham?
Yeah, again, the commissioners make the decision. It seems pretty random. They usually do it when they want to just give someone a little bit lower bail. They've been putting them on. We've been objecting a lot for a couple of reasons. One, the violent people they're starting to put on. We had a pretty severe incident last week or earlier this week with someone they put on. But again, it's just how, it's just case by case, I guess is the good way of putting it. I know the judges are doing a good job when people are coming in to quash warrants or they're reducing bail. They're also putting people on it as well.
So then I guess I just wanted to put in a plug for wherever the discussion fits that sometimes it might be helpful to both set bail if the court finds that's appropriate and also refer to pretrial services. I just did some review of some of the higher lethality risk domestic violence cases with recent pending Superior Court charges and finding that bail was set in most of them and people posted bail and were out in most of them, and pretrial services were typically not ordered except in one case where bail was reduced at one point. So just keeping in mind that it seems like the pretrial services could be a really helpful addition, and that sometimes when bail is set, that doesn't mean that somebody's not going to be released and wouldn't benefit from that support.
Maya, see you have a question, but can I piggyback on just her thought really quick about, thank you. So going along with what you were just saying, Ms. Donovan, is that Kelsey and I have been tracking, mostly Kelsey has been doing a great job tracking the decisions that are made. So for March, I can see that PR with pretrial was 2 people, bail with pretrial was 7 people. And then April, we have bail with pretrial was 16 people, and PR with pretrial was 6 people. So those quick numbers, it's pretty obvious that they're doing both.
I recall from the Arnold Venture materials that it was supposed to be bail or pretrial. Like the impression, and it's been some time since I reviewed those materials, but I thought the best practices stuff said you shouldn't do both. It's one or the other. That's what I recall.
Well, I think nationally, they're trying to change that. So historically, it has been bail. That's a way to assure people's, appearance in court and things like that. And so I think nationally, they're trying to change it so that, yes, everybody ideally is PR. But going along with what Judge Jones was saying earlier, I think they balance that with all the court rules they have to follow and to make the right decision at the time. So I don't know what current research shows about bail with pretrial or just PR with pretrial. But that's something I could definitely dive deeper into.
Yeah, I think your predecessor looked into it and talked about the best results were actually with people with bail and pretrial. That those, from what he saw, and I think from his former job, I saw. I remember that being like the number one compliance was a combination of those 2.
Gotcha. Thank you, Dave.
I have a couple of questions, Judge Jones, about the bench card. One, there isn't a spot for performance bond on here. That is something we've been trying to get the commissioners to follow, because there's a lot of individuals who, and I sometimes have offered less bail if it's performance bail, where we're just worried about their conditions, not so much for it to appear. Mainly the violations, individuals keep on violating protection orders are a huge thing. And also people keep on returning to areas they've been trespassed from. But I noticed that wasn't on the option. Are we not going to do performance bond in our county?
Well, let me ask you that. I was under the impression that there were no bonding agencies that would draft a performance bond. That wasn't an option available in the community. We just have appearance bonds, which would mean then that the only way to condition performance would be through a cash only bail, and I don't think we're allowed to do that under the Constitution. So
yeah, but no, I know, like looking at the rule, you also have to do, if you do performance bond, there also has to be amount for a appearance bond. When I was just looking at the 3.2, they talk about it that it's like 10% of the bond could be a performance bond for the conditions.
but that doesn't that imply, Mr. Graham, that there's like somebody out there that'll write a performance bond, a lucky bail bondsman or somebody that'll do that?
No, because it also can be done in cash, and it's like a 10% cash.
Okay.
But that's just one thing. It would probably make our recommendations lower if we had that option. That's one. The other thing, looking at the pretrial service release condition in action, am I correct that the only people who are going to be reported if they don't show up to pretrial services are individuals on high level? That's kind of the way I see. There's an informal notice to the court, but the only people we're going to get the violations filed if they don't report to pretrial services are those just on the high level.
As it's written right now, yes. So
Okay.
the condition is when they're assigned that when they are released, if they are released pretrial, that they are to report to our office within 24 hours or make contact with our office within 24 hours. So if that doesn't happen, just like you mentioned, yes, an informal notice or a failure to report goes out, just saying, hey, this person was assigned on this day, failed to check in within 24 hours. But for anybody receiving a notice of alleged violation where a commissioner or judge makes a decision on, is that what you're talking about, like the NAVs?
Yeah, because the first two, then nothing happens to it. So low and mediums don't have to report.
Well, yeah, well, they get that notice to the court. So again, these notices aren't necessarily, so by providing the notice, we're not the ones saying that something should happen. We're saying this is what did happen. It's kind of in the prosecutor's hand. Hey, do you want to, file a review hearing because they didn't show up to pretrial? So it kind of puts the ball in their court. But as for the actual notice of alleged violation where the commissioner will make a decision, that those are the ones on high. And if
Okay.
they're out of compliance, that's when we'll send those out.
Okay. And we've been getting some of those back, but the commissioners aren't taking any actions on the failure to report for high level. So we started objecting to all pretrial services as if we're kind of making this voluntarily.
Yeah, no,
for
and
them
I
to
think
show
we kind
up.
of briefly had this conversation the other day,
Yeah.
before first appearances. The intention wasn't that, or I should say, it was never supposed to be implied that by them checking no further action, that they don't care, because that's never what it was intended to be, kind of interpreted or seen as. The idea was that by them saying no further action, it's that they want the prosecutor to make a decision and say, hey, should this person come back in front of the court? Should we readdress bail? Should we readdress release conditions? Should we do something else? So it's, I'm sorry that it did appear that they're not caring, because they are.
I guess not so much caring, but we read it, and I read in the record the other day, if commissioners already decided no further action is taken, our office isn't going to bring it back in front of the court and say, hey, commissioner said no further action on this, but we want this reviewed. It seems like if the court is getting a violation, this person didn't report, and the court's deciding, hey, no further action, we can't come back in front of the court and say, you've already decided no further action, but we want further action.
Sure you can. I mean, Alan's right. That's not that. So there's a difference between the court deciding sua sponte to bring somebody back in front of it for a modification of condition hearing. That there's a big difference between that decision and the decision of a prosecutor who might have more information about the case, might understand things that haven't been presented to the court, to petition the court as a party to the litigation to modify release conditions, to issue a warrant, to do any of the things that you can do once you've been told by the court, pretrial services, that there's a violation. Although one, that the court sees as in its isolation as maybe minor, it could be very major in a constellation of other things. We do not mean, Dave, nobody means on the judge side of things to preclude the state from being a moving party to review release conditions based on information we've discovered through pretrial services.
But if the court is ordering and the court's monitoring the pretrial service division, and then the court just says, continue pretrial service with no further action, you're saying that then we have to renote it.
Yeah.
But to us, it's sort of like, well, this is the court's program. And if they're deciding not to keep it on, how are we to bring it forward? I guess. But you're saying we get this and then we're supposed to note in a pretrial violation.
Right. You're supposed to file a motion to review release conditions.
Okay.
We're the moving party. We're the state. We've been told this gentleman didn't appear as directed. We don't think he's going to follow court orders. We want the judge to review release conditions.
Okay.
I mean, in the same way you would, if you heard any information from the community that made you concerned about somebody's risk.
Oh yeah, and we understand. I guess to us, it's just, well, this is why I have pretrial services. We'd be doing this anyway, I guess. And then the second thing, which I saw, and I'm not on the criminal calendar every Tuesday, but I saw some objections to, they had a couple notice of violations, that it's a non-mandatory appearance for the defendant to be there at these hearings. And I guess my pitch is, if that is true, then if we are putting people on pretrial, can we add that it is a mandatory appearance to show up for violation? Because then again, we wouldn't even note any of these. The defendant doesn't have to be there. It's sort of moot about it. Has there been any discussion about that between the judges?
Yeah, and I think we need to maybe all sit down the stakeholders that are involved in how the reporting goes and how the summons to court looks for a hearing. We need to make sure everybody's on the same page with that, because we aren't, it sounds like, as far as what the obligations are once you've been noted by pretrial services to be in violation. Because You know, it could look a lot different if the state moves to amend release conditions and provides notice to the defense attorney, those sorts of things that we all recognize under the court rules. This is a little different, just being a note from the court itself that somebody's in violation. So we have to figure that out. I don't know the answer to it.
Yeah, because I know we looked at the rules and the court can bring someone in front of the court at any time. Because there first was this objection that the state had to note this, all the violations in, and then someone pointed correctly that no, the court can do this. The court can always bring the parties. But I guess we're having a tough time with the program if it's, low and medium don't really have to report. They get an informal notice and we have to monitor, even though there's a notice of violation, someone not reporting, we have to step up and do it. It sort of doesn't help our office at all. I mean, before it was a good selling point that, hey, court's going to be monitoring these people. There's violations. Court's going to note it up. We show up and take care of it. It seems like we're monitoring the program now, not really the court.
Well, it's information you would have never otherwise known if the court didn't require it and then let you know if there were violations of it. So there's benefits in that way, I would think. But I don't mean to end it in kind of a awkward silence, because I do think there's a lot of room for discussion about how we're gonna bring people back if they need to be brought back to review release.
Yeah, and then I guess I'm also sort of worried about even this last individual we had about is the liability then shifting to us if we're not noting these people in, if the court isn't, because we had the incident this last week, which is pretty bad. Someone didn't report and all that, but are we going to be liable because the court put someone on pretrial services and then we didn't note it up because the court did? I guess that's maybe something I should ask the civil department how they want us to handle that. Because it sort of seems like the burden's shifting to us to monitor this rather than the court.
Well, so and also I don't. So you're I wouldn't say getting hung up, but you would like lows and mediums to be able to be, for lack of a better word, violated as well, right? To have their violation report brought before the court.
Yeah, I think the court, if the court is ordering someone to report to pretrial services and they're not, I mean, it's one of their conditions. It's the same as any of the conditions. I mean, and to us, it's like, well, why put anyone on low medium if they just get a free pass?
I wouldn't necessarily call it a free pass, but I mean,
what happens if they just don't report? You send the informal notice, the court does nothing. They can go the next 2 years not showing up. You're still, I assume you're still giving them the text notices to show up and at least assisting that way. But other than that,
I think the pretrial services department, Dave, it's meant to not just be a enforcement wing of the court. It's really not meant to be that. It's meant in large part to be a service and assistance to try to minimize through affirmative interaction, case management type interaction with folks, and affirmative assistance to direct them to services in the community and to get and to hopefully thereby encourage appearance in court and reduce recidivism. So it's to the extent that we're not being as effective as an enforcement wing maybe that's true, because there's other enforcement wings that exist, like the prosecutor who's a party to the case. So we are maybe this shift that you're sensing is more of a focus on that affirmative service-based work that the court thinks is equally as important, and less of the enforcement-based work.
Well, I can give kind of an update on the department while we have kind of a lull here. I already kind of mentioned the March and the April numbers about PR with PTS or pretrial services and bail with pretrial services. So in March, it looks like we did. These are just general numbers about how many people are reporting and the amount of appointments we put in our calendar and are actually completed. So in March, 91 of 104, which is an 88% report rate to our office. In April, 131 of 154. It's an 85% reporting rate to our office. Right now, our numbers are 28 on low, 32 on medium, and 36 on high, with 96 total. 33 of them are currently in custody. In March to present, we've handed out 23 bus passes. In March, we ran 112 PSAs. I don't have the breakdown on what they scored, low, medium, and high, or what that statistic is, but I can say we ran 112 PSAs in March and 111 PSAs in all of April. Those are just quick glimpse at the department.
Alan, I'd love to, if you are able to share that report through the work group, that would be really cool, because I'd like to share it with our team here.
Which report is that?
Whatever you're referring to.
Oh, I run a query on our software. Do you want it? I mean, it's very it's messy.
Probably not if it's like indecipherable, but if you
No, you can.
create reports like you just articulated and were reading to us, do you
Oh.
create a written report that says this is how many people we served, this is how many people got both bail and pretrial, this is who got PRs and pretrials? Like, those numbers would be interesting to our folks who are working on first appearances.
Okay, yeah, it's not all centralized. We actually, so the bail and pretrial who's referred tracking, that's an Excel spreadsheet. The bus passes is on a handwritten piece of paper in the office that we count up.
Well, maybe just an email with the information you just recited would be enough. Like, I just would like to encapsulate the work you're doing and explain it to our staff.
Yeah, that's reasonable.
Thanks.
Of course.
Anything further on all of that? I recognize I was away for part of it. By the way, a family member had surgery and it went well. Yay. That was my call. So beyond that, do we have other items for discussion today? And am I cutting off this discussion prematurely? I don't mean to do that. Well,
No, I think we discussed it all.
okay.
Hey,
Judge
I had
Jones,
one-
you have anything you'd like to add?
Yeah, just real quick. We just because I think it might interest this group, that the judges are engaged in our annual process of reviewing our local court rules, and some of the discussion of the local court rules this year includes the proposed or potential changes to the criminal calendaring system, and some discussion about how we run our criminal calendar. Those rules are going to go out to the stakeholders and to anybody for public comment by June 1st, for submission to the state by July 1st. So I just wanted to put that out there, keep an eye out maybe for the ability to comment on those rules. I bring it up specifically because the judges are thinking about the VERA report and some of these goals of reducing the amount of time a case is pending in court, having less, more effective court hearings on criminal cases. And we're trying to think about our court rules and that's how we might influence those goals. So we're going to put that out in the next month.
Thank you for that reminder. Yeah, and that's, I wonder when you prepare a draft that you're going to send out for comment, could you send a copy to Jill, and then Jill, could you send that draft to the members of this committee?
Yes, I'm happy to.
And
Yeah,
is that
I'll-
workable for you, Judge Jones?
For sure.
Great. That's a good thing.
And that's what I'll do with, sorry to interrupt, that's what I'll do with my numbers too, Ms. Vanu. I'll send it to, okay,
You'll send it to Jill so we all get it? Good
Good.
idea.
yes.
Yeah, okay. Anything, do we have other topics for discussion today? Anything else let's see, I finally identified a hand up. Maya.
That's my failure to lower it. Thanks, Judge.
Oh, okay.
The one time you got it, Deborah.
Exactly. The one time I got it was a false alarm. I think most of the members of this committee know by now that you have to really do that if you want me to call on you, because I just never seem to notice those hands. All right. I feel like we're moving along well here, and in large part because of the work of Judge Jones and Alan. Thank you both. I think we should make a plan for our next meeting to be in June, and we'll take things from there. Anybody have anything they'd like to say or share with the group? Well, thank you all for your presence and your discussion, and I think we did well. So onward and upward. See you next month.
All right, thank you.
Jill
Okay.
here, just for the record for everyone, we don't have any attendees in either our conference room, it looks like, or online. So it doesn't look like we have anyone for public comment. Thank you.
For clarifying that. Okay, thanks to all.
Thanks.
Bye.
Bye.
Bye.